Hello and welcome to Legally Speaking with me, Tarun Nangia. India is one of the world's busiest markets or geographical zones for disputes. And why disputes? Because all the growth of the world is happening in India. We are looking to become a $5 trillion economy. Investments in infrastructure are topping $150 billion. New roads, highways are being built. Greenfield plants are coming up. Also, you see a lot of investment happening in urban infrastructure. All of this will give rise to a lot of disputes, and disputes need to be settled quickly to save time, interest cost, money, and so on and so forth. That is where the issue of mediation comes in. We are calling high value mediation because when billions of dollars are invested in India, it calls for quicker dispute resolution because big money is big interest cost and the turnaround time needs to be as quick as possible. So that is why we will discuss high value mediation, and of course litigation is an option if high value mediation can only succeed up to a point, but in many cases high value mediation is all that is required to settle a dispute. A good mediator can do that. So today we're going to discuss that issue in detail. I have a very eminent panel to take you through all of this. I have with me today Justice Arjun Kumar Sikri. He is one of India's leading arbitrators and mediators, somebody who as a Supreme Court judge also pushed the cause of mediation more than anybody else. He also is a judge of the Singapore International Commercial Court. My second guest is Senior Advocate Sanjay Jain, a leading lawyer at the Supreme Court and the Delhi High Court, also works in the field of alternative dispute resolution. He served as the Additional Solicitor General of India for 9 long years until recently. So he has a view of how the government thinks, and now he is back to private practice, so he can give you both sides of view from both the sides. We have with somebody we couldn't do without industry participation because industry generates all the arbitrations and the mediations. They are the ones who will give you the real view in the sense from the user's perspective. So we have with us today Dr. Sanjeev Gemawat. He is the Group General Counsel of Vedanta, which is one of the world's largest mineral mining and resource companies, and he will share the industry perspective. Thank you each one of you for making time and joining me today on this show. At the outset, sir, I would like to start with you. If you could in the next 5-6 minutes encapsulate the issue of high value mediation and how can it help the industry at a time when investments worth billions of dollars are happening across sectors. I mean, I'm not limiting it to infrastructure. Every sector is having a lot of, and they're all looking for quick resolution. Over to you.
I think, Mr. Tarun Nangia, as you have rightly mentioned in your introductory remarks, because India wants to become a 5 trillion economy very soon, so it is on the path of growth. And because of it, there are so many infrastructure and other very big projects are being taken by the government and private sector. Another dimension is that, which is intertwined with this, is that with the globalization and for such growth, foreign capital is required. We want foreign direct investment, which has been happening. So India is, I think, after China, largest recipient of foreign direct investment also. And because of this, capital is flowing from other countries. This technical know-how is also coming to India. Because of that, collaboration agreements are taking place. And there are two implications of this, if I may say so. One, you have already pointed out that because of this, the disputes which are bound to arise, and with so much of infrastructure and big projects with foreign capitals, etc. So one thing is that disputes would arise, and therefore that dimension which you have pointed out, if these disputes arise, they are going to be of very high value disputes normally, and that is what is perceived. And if you see in last 10, 15, 20 years, So the high value disputes and the number is growing in the term of number of cases also, and quantum also of
Yes.
those disputes. Second aspect, which is very, very important from our point of view, is that with this kind of technology, etc., coming, and different kinds of, like, even money comes, shareholders agreement, under which it takes place, stakes are bought, equity stakes are bought by foreign investors, and within India also, if somebody is so it leads to, when the disputes arise, whether it is on technology, on patents, etc., or whether it is under shareholder financial stakes of the parties, the disputes are becoming very, very complex.
Complex.
This is very, very important aspect, that its disputes are becoming very complex. And therefore, now on the one hand, as you rightly mentioned, that these disputes need to be settled as quickly as possible. Another aspect is that while disputes may arise, it may arise when say some agreements, a collaboration agreement or project which is undertaken by, say, some private company from the government is still going on. So it should not affect those projects. It should not affect business, because if disputes arise and the relations become sorry, and it has the effect on those projects, etc., it is not good for
Yes.
the interest of the nation. So therefore, the relationship between the parties, which is there, the parties want that it should continue.
Yes.
Now, in this background, what is more important is that we have to understand, and Dr. Saab will tell us more about it, because he belongs to the industry sector, what business wants, what business community wants, and when the disputes arise, what kind of resolution they
Yes.
want. Very first thing which has to be kept in mind, and this applies across, whether a dispute is decided by the court, or dispute is decided in arbitration, or a mediator is setting the dispute, that what is the need of, here I'm not saying out of the two parties to litigation what one party want or what, I'm saying generally what business world wants. They want some practical solution to the dispute, that the solution which should emerge. And in business, or in some solution, we can't say that 2 plus 2 is always 4. So therefore, there may be certain situations where out of box thinking is required to settle those disputes. And so that is the demand of business community, that you should understand what we want, and that kind of resolution should be there. And number two, which I have already said, that during this period our relationship should not that should maintain, that should be maintained. Now, that was one of the reasons, you see, our traditional system, court system, from court system as well as business, and I'm limiting my discussion to only high value commercial disputes and how they should be resolved, that when it comes to commercial decision, that it was thought, and rightly so, I don't say, that yes, these disputes, for various reasons, and when we have adversarial system and courts are overburdened, etc., and the judges may have different kind of disposition towards these cases, which may not be very conducive. So therefore, they are better resolved through arbitration. And more particularly, it was that yes, depending upon what is the nature of the dispute, we can pick an arbitrator of our choice who is very much conversant with those kinds of disputes and can give us some practical solution. And more important was cost and time.
Yes.
That it should be cost effective, it should be time effective. But over a period of time, it has been found, of course, arbitration is relevant, remains relevant even today. But over a period of time, it is found that under certain circumstances, even arbitration is not able to meet this demand, that cost effective or that time, this thing, or is able to, after all said and done, arbitration is also adversarial system.
Yes.
And therefore, sometimes there only two arbitrators decide again as what the contract says and what should be our decision in terms of contract. And our section 28 of the Indian Arbitration and Conciliation Act clearly states, which is the principle incorporated on international law principle in arbitration, that a judge arbitrator cannot decide on equity. They have to decide only on the basis of contract and what contract provides. So many times the solution, if they that equity says something else, but I have no jurisdiction, I have to decide. That may not be in a given situation good for business in that particular case. So here comes mediation.
Okay.
So relevance of mediation comes here because mediation is, as I said, it's not always 2 plus 2, 4. It is not adversarial where you hear both the parties, either one party is right or the other party is right, or partly one party right, partly other party right. They have taken their positions. You decide which party is right, which party is wrong, and what is the due from one party to other, and you decide on that basis. Mediation takes it takes into consideration interest of the parties, what is good for both of them.
Yes.
And there may be not one or two, maybe 10 or 15 or 20 alternatives, which may be there, which can be thrown open to the parties. And on that basis, the parties can decide for themselves what is in their best interest, on which I'll develop later on because you wanted to ask me. So here lies the importance of mediation in high commercial disputes, which many times can be settled in 1 or 2 days' time, or maybe in a few days or within a month or so, where even in the arbitration it sometimes takes years today. So that is where in this whole scenario, mediation becomes a better choice.
Thank you for that opening comment. I also understood from your answer that mediation looks like a win-win situation for both parties, not that one party loses. It looks like both win. I'll take this to Senior Advocate Sanjay Jain. You have represented the Government of India for 9 long years. For the past year and a half, you are in private practice. So you have defended the government, so you know the government side. Now you are appearing for private parties. You also do arbitrations. Given that as a background, you understand the urgent need that whenever there is a dispute with the government or between private parties, how much of pressure there is on the company to settle quickly, because they have to justify the shareholders and for the company to run as a going concern, because in high value disputes, the amounts involved are in thousands of crores or hundreds of crores, which are big amounts. Given that as a background, could you give me your opening comment?
See, in my view, in high value disputes, there is an enormous pressure on the management of whether it's a private company or a PSU, or even for that matter any government department, whichever way we look at it, there is an enormous pressure to reach a solution in the quickest possible time. Now, how does one achieve it? Of course, arbitration is one such option, as we all have been exploring. But post-COVID era is a reflection. It gave an opportunity to reflect, and the reflection came in the form of reappreciation of the arbitration clauses which were already inserted in most of the arbitration agreements, that parties will first try to resolve their dispute amicably, even if expression mediation is not written, but the intent is the same, that the parties would try to resolve their disputes amicably amongst themselves. And if that process fails, then in that eventuality, the arbitration mechanism gets kicked in.
Yes.
But the tendency was to ignore the first part and just to do some kind of a formality, sort of a lip service, that yes, we have tried to resolve it amicably, but we have not been successful. So the time is ripe to go for arbitration. So there was an unusual haste in rushing towards arbitration, and that was considered to be the only viable or acceptable option to the parties. In my view, post-COVID, when several grounds on the basis of force majeure and other aspects came to be taken by one of the party to the dispute, then the realization came that it is better that if we inch towards a quicker mechanism for solution, particularly in the high value matters.
Yes.
And this realization was totally recognized in the Western world. If you see, 92% of the disputes pertaining to the trademark and particularly in the telecom sector,
Yes.
which were handled by WIPO, they were resolved through mediation. There are n number of other international institutions which put their heart and soul in igniting and putting a lot of strength in mediation process, and the result was that the success rate ranged from 70 to 90%.
70 to 90%.
And this is an eye opener for the industry, whether it is a government side or a private side, that mediation is not meant just for lip service. It is a serious business, it is a serious tool of ADR. It is a worthy participant or a worthy constituent of overall ADR system. It is not a country cousin of arbitration. So that realization has taken place, and if mediation has succeeded at different level in resolving the disputes at a lesser high value commercial disputes, there is no reason why it would not succeed in high value disputes. Rather, there is a greater possibility of mediation succeeding in resolving high value disputes because the desperation level are much more higher. The possibility of waiting for a contested award is something which many a business entity may not be in a position to take, because it disturbs the calculation, it disturbs the banking arrangements, it disturbs the ecosystem. So why not go for a mechanism which, as you said, and His Lordship Justice Sikri mentioned, that is a win-win situation.
Okay. Thank you for that opening comment. I will take cues from both of your answers where Justice Sikri alluded to a lot of complexity, which you shared in your first answer, that high value mediations may involve so many components which make them complex. And we'll take this to Dr. Gemawat. Now, I asked this to you not only as GC of one of the world's largest mineral and mining companies, which is Vedanta, but you represent the General Counsel Association of India, of which you are the founder. So in a sense, you speak for the GC industry in India, which has got over 100 members, if I'm not wrong. In your opening comment, if you could address the issues that the other two panelists addressed, but also the issue of complexity and the need for quicker dispute resolution, and the pressures that somebody like you may be sitting on when disputes have to be resolved. You're in constant touch with the promoter or the CEO, and why it is important for them to be resolved and what kind of impact it can have on the economy if this is delayed. Does it impact investments and so on and so forth? If you could just encapsulate all of this and speak for the industry in your answer.
Perfect. Tarun, thank you very much for having me here. I will start with what Justice Sikri started, and I think he started with that $5 trillion economy. We are right now in an Amrit Kal, and this Amrit Kal is now not 25 years. Amrit Kal is now less than 25 years. So this Amrit Kal is dependent on two major schemes. One is the which we say this Gati Shakti, yes, which is the national infrastructure master plan, and the second is the national infrastructure pipeline, which was for 5 years from 2019 to 2025, nearly somewhere around $1.4 trillion kind of investment. Now, why I am giving you this perspective, that this master plan on infrastructure and this national infrastructure pipeline, it's a huge investment, because that Amrit Kal of 2047, what we are targeting is $26 trillion economy. The GDP would be $26 trillion. So I'm not right now resting at $5 trillion or $10 trillion. It's a $26 trillion or $30 trillion economy. Now just think about it. This infrastructure gap cannot be filled by Indian investors for two reasons. One is we lack technology right now to address that, and the second part is we need capital, yes, to fund these projects. Now both these things would be coming from outside India.
Yes.
Of course, internal investment would always be there, but outside India. Essentially, it means that there would be multiple cross-border transactions, multiple, trades and agreements and contracts and so on. This is the backdrop. And in this backdrop, if we notice that we are right now very poor on enforcement of contracts.
Yes.
That is the one of the biggest problem as far as ease of doing business is concerned. Now, the moment you keep that into perspective, you will realize that for these all high complex kind of transactions and contracts, you need a right kind of justice delivery infrastructure. And do we have this justice delivery infrastructure as of today? Answer is yes, we are trying. For last 2.5 decades or so, we are trying after the 1996 Arbitration Act. But then still, we are lagging behind. So I agree with Justice Sikri that mediation would be a better mechanism, particularly in situations where there is a continuing relationship, even if there are complex transactions, but there is a continuing relationship. Now, in that situation, parties would always be having the intent and willingness to settle through mediation. Because for mediation, and let me tell you, mediation has not been successful so far in India.
Yes.
For the simple reason, parties would never want to open their cards at the mediation where there is no mechanism of enforcing the settlement which is arising out of mediation.
Okay.
And so from that perspective, I would say that mediation, and Justice Sikri rightly pointed out, wherever equity is there, I think mediation would be the quickest mechanism of addressing disputes. So this is what opening comment.
Thank you for that opening comment. We'll go to Justice Sikri for this. Time and again, whenever I speak to promoters, they tell me, Tarun, you have no idea that disputes in India will go up almost 6 times. Because as economy doubles, disputes go up 6 times. And we are not in a position to handle, because there will be so much of work and less people. And when I say less people, also less people who are of a certain quality. When you said complexities, not every mediator would be trained to handle such disputes. And the quality people are really few. And on which, if we load them with 6 times more work, then the whole system may collapse. In that case, many of them say that mediation is the only way out, that as much as possible settle things to mediation, and of course the litigation route and the arbitration route is open. Given that as a fact, if you can suggest some measures, also I want to ask you, for example, if there is a 18,000, 20,000 crore road project, which we see many now being awarded in India. This project takes 5-6 years to complete, and there are so many disputes along the way when the project is completed. Can there be mechanism for such projects that disputes will be settled through mediation, or that should be the preferred mode for settling? Can there be some understanding in which it is assured that the project would be implemented on time because the disputes are solved on time? If you could address both these areas.
Okay, thank you. And I think to some extent Mr. Jain has referred to this. I'll expand on that.
Yes.
As he rightly mentioned, and particularly during COVID and post-COVID, we realized so many disputes are arising, and you further rightly say that the disputes are going to, number is going to increase, etc. And therefore, there should be, mediation has its role to play, and in many government contracts particularly, and with PSUs, and even private contracts I have seen, there is always a clause that before going for arbitration or litigation, if there is no arbitration clause, parties will try to settle between
mediation.
themselves, whether mediation is used or not. As is that in somewhere mediation is used, somewhere conciliation is used, somewhere is that good faith discussion is kind of expression which are used, but they all are the species of if one really wants that, a species of mediation. And see, parties have realized, I would say, as I said, about the limitations which are there in arbitration system, etc. And particularly in last few years, even all big arbitration centers, whether it is Singapore International Arbitration Center, whether it's Hong Kong Center, whether it is LCIA, that is London Council of International Arbitration, whether it is ICC, Paris, or even in America, etc. Everywhere they now have realized that even now they are doing arbitration work, but even before going for arbitration, let there be mediation. And they encourage that. And many have now inbuilt mechanism, and this answer comes to your query, that we have this system what we call med-a-med.
Okay.
mediation, arbitration, mediation.
Okay.
That there should be mediation if the dispute arises. Parties agree that we'll go for mediation.
Okay.
If for some reason mediation is not, getting successful, we go for arbitration. And many times during and there are many cases or many anecdotes on that which I can share. Many times during arbitration, they again feel
Mediation
that
is better.
yeah, on these aspects we can discuss and we can settle between
The
ourselves.
mediator arbitrator is the same person?
No, normally they should not be,
Okay.
because there are two ways of looking at it. That community really wants that, this business community or even the arbitration centers, etc., that a person who is doing arbitration normally I am saying should not act as a mediator, because for mediation it should be sent, like we have court and ex mediation.
Yes.
So courts do not, if a particular court is having, so they will send to somebody else outside for mediation. And many times even if it is judge is the mediator, as we had started in Delhi, 30 Hazari courts as a pilot project, where a judge would send to another judge, but then another judge in the capacity of a mediator will do. But having said so, there is a provision under our Indian Arbitration Conciliation Act, if the parties agree that the same person should act as mediator, and if they have faith in him that yes, if as mediator he does, because the person should be very competent, in the sense that when I am doing mediation, I am wearing that hat. I know what I have to do, I am supposed to do as mediator, and if that is not successful, I am revert back to mediator, I am able to wear that hat. And I am not influenced by whatever was discussed during mediation. So it needs that kind of high level training, but therefore normally they are different persons, but there can be same person also if the parties give consent to it. So that is one of the basic thing which needs to be kept in mind. And let me say one thing very clear, and Dr. Gemawat said, and rightly so, that sometimes parties may not have some kind of faith that whether it will yield some results, etc. or not. Or what is to be kept in mind is, and this is what the business community and even lawyers and others who are all stakeholders, they should know the merits of mediation, that it can do wonders. And I give you one example. I remember I mentioned you about the complex nature of issues, etc. So one way of looking at it, and many look at that, these kinds of so many complex legal and factual issues which are arising, how it can be settled through mediation.
Yes.
When it needs so much of evidence, and it will be gone into, and the arbitrators will have to put their mind together to come to a solution, how it can be. And I still remember when last year Justice Sundesh Menon was, we had in Delhi High Court organized one conference, Delhi High Court had organized one mediation. So he was here, he gave the example, he said many years ago when he was himself a lawyer, and there was very complex, high value dispute which had gone for arbitration. In the arbitration, the arbitrator suggested that, look, why don't you do mediation? He says, I was new to mediation. I said, that such kind of issues, and how is it possible? He says, reluctantly we went for that mediation, and the mediator could settle that in 1 day's time.
1 day.
Where he says that, look, the documents, if you see because in these complex issues or cases, I tell you 100,000 pages worth document, sometimes even more than 1 lakh pages, which are filed by both the sides. And I know in some cases I have 20 bags lying in my office, or it is on, otherwise, it's on iPad. This kind of, record is there. But as I said earlier, mediator straight away comes to what are the interests of both the parties and how that can be done. And if on that basis parties are near that solution, they will forget about the legal niceties, etc. Because ultimately what happens on legal nicety, a case is decided in my favor or in his favor. No, the businessman is not basically concerned with that. Lawyers may be happy, oh, it was such a this matter, this legal complex issue, and I have won, and all that. But as far as business is concerned, or I mean, that the parties are concerned, they are mainly concerned with the outcome.
Yes.
Whether the outcome is conducive, which appeals to them, and therefore they will keep aside all those complex issues and would come to those. So that is what mediation can achieve. And therefore, I would say that you see, for example, I go one step further. In 70s or early 80s in America had same problem like we have in India today.
Okay.
Was overburdened with case law in the courts.
Okay.
And they also thought court system is collapsing. Mediation came, and today 95% cases are settled through mediation, and only 4 or 5%
So
cases.
that society has accepted.
Yes,
it.
society, and 5-6% cases go to court.
Yes.
So court's burden is eased.
Yes.
That sense, in that sense. So I always use the word mediation saved judicial system there.
Yes.
Like it can happen in India today.
Yes.
And mediation is saving arbitration system also.
Why- how so?
As I said, that in because I give you the example of exact example of bilateral investment treaty disputes,
Yes.
BIT disputes, which are again of very high. Every dispute is very high value.
Yes.
And on the one hand, big companies are involved, corporate sector. On the other hand, such bilateral investment treaty disputes are filed against the government, particular, which is a sovereign government, any nation, it can be filed. And over a period of time, the including India, the resolutions of that through arbitrations are not acceptable to many, particularly the sovereign governments, and it had led to much controversies. And ICSID is one such this institution which normally does, and it is the only exception where the arbitrators, what they decide, are printed. Normally arbitration is, the award doesn't have precedential value.
Yes.
These are rather under section 42A and international community also, arbitrations are confidential, which is one good thing. But ICSID awards are normally not only published, but they are quoted also.
Okay.
But then over a period of time, and there are few examples which I know which led to controversy, and in India also there is a very famous or infamous case, White Industries case, because of which India even terminated most of the BITs and are going into new regime. But realizing this, again, all ICSID and others have introduced the mediation. The first has to be compulsory mediation when the notice is given by then to the government, 6 months cooling off period, that government will have time, and then during that period they can go. And even if you come, first mediation, if mediation fails, only then the arbitration will start. So in that sense, they know that in order to save our arbitration system in BIT, we should introduce mediation.
Interesting.
So in that sense, I said that mediation is good. So therefore, if this, and of course, there is one discussion which had taken place, coming back to again that what kind of systems could be, and once we were having this Mediation Act which
Yes.
was passed some time ago, and during that period there was one topic which was discussed very hotly, whether mediation should be made compulsory.
Okay.
And before going to the court or going for arbitration, you have it's compulsory, unless you, like under our Commercial Courts Act, for cases up to some particular limit, you have to.
But I'm sorry to interrupt. Do I have a choice for my mediator if I want to go to eminent mediator, or the court will select?
No. There are two types of. In two situations there will be different answers. If the parties have already gone to court, and court annexed mediation, so court is referring under section 89 of
Yes,
CPC,
yes.
then normally the court will send to mediation center, like say Delhi High Court Mediation
Mediation
Center.
Center, okay.
So they will appoint one of these. But if it is pre-litigation mediation,
Yes.
and particularly it has happened,
Yes.
parties have come to me, there are 4-5 mediation, pre-litigation I have done, where both the parties, and in some cases one party was even public sector. They thought that before going to the court and or arbitration, if it can be settled of their own, they said okay, and they agreed, both of them agreed, and they came, and I have been able to get a few of such cases settled also.
Okay.
So therefore that becomes party's choice. Normally, like in America and in most of the countries where mediation practice has today developed, and it has matured a lot, and you will find many very, very good mediators who are not only trained mediators who have done mediation cases of international, mediation cases, and they have quite a good experience. So people by choice would go to them.
Okay.
So we have few such mediators in India who are, and over a period of time, more mediators would come, and so therefore it would be a party's choice. Like arbitration, if dispute arises, I want to nominate X, other side will nominate Y, they will nominate some chair, or it is sole arbitrators, both the parties can agree, let us go to X. So likewise, in mediation also, it's party's choice. But if it is court next mediation, then court sends. Yeah.
Thank you for that input. I'll take this to senior advocate Sanjay Jain now. You are somebody who has batted for both sides. You batted for the government for 9 years. Now you are a defense lawyer for private parties. Given that as a fact, and you do arbitrations a lot, could you share with me two things? Why we stress on infrastructure on this show? Because the government's priority is infrastructure. The government is putting $150 billion. It is more money than many times of any other investment. Infrastructure is what is the government's theme for the next many years. And if you're looking at 6 times more cases, then it is in the government interest to also settle. How do you think mediation will be used in high value infrastructure cases? If government is giving out contracts of thousands of crores every month, some of the other big contract is awarded. How do you see this being used to solve quickly disputes? And also, if you could suggest, see, we have many mediators, but we lack mediators with complex minds who can solve disputes which have complexities as alluded to by Justice Sikri. If it's a complex construction contract with hundreds of variables, not every mind can assimilate. There can be simpler mediations. But for them to be able to trust a mediator, you need mediators of certain eminence. Do we lack it? How will we fill that gap?
Tarun, in my opinion, the greatest enemy to the advent of mediation in this country is the trust deficit.
Okay.
The promoters or individuals or the litigants, the GCs, they do not believe in their thinking or in their heart, whichever way you look at it, that we would succeed in mediation, and there is a lurking doubt in their mind that whatever they discuss during mediation process or the discussion when it takes place, the confidentiality aspect may be compromised. So there has to be some mechanism. In any case, now the Parliament has taken an initiative by coming out with Mediation Act in 2023. Section 5 does contemplate pre-litigation mediation. In addition to Section 12A in the commercial disputes, commercial courts, which also contemplates pre-litigation mediation, as His Lordship Justice Sikri just mentioned. So, how do we address it, as you said? First of all, the arbitration clauses have to be reworded in the sense that they have to be integrated with this scope for having mediation first. Then, if mediation initially doesn't succeed, it doesn't mean that it's funeral to the mediation.
Okay.
After that, when you migrate to arbitration, as His Lordship mentioned,
Yes.
then you can again go back to the mediation, and it will in fact be preferable that one of the arbitrators, in case it is a panel of more than one arbitrators, or if it's a sole arbitrator, if the parties choose that person only as a person who would mediate, because with him you will be able to, with him or her, you would be able to save that time of acquainting the person, the mediator, because when he wears the cap of a mediator, he knows that it is no more, he's no more in adversarial system.
Yes, yes.
That person understands that. I mean,
Yes.
the people who are adjudicating the high value disputes, their eminence is not in dispute at all. So those persons know that when they will pick up the hat of a mediator, what confidentiality that is needed to be maintained would be maintained. They would forget as to what all adversarial aspects are there, but nonetheless they would know the stands of the parties. So it will be possible for a very quick resolution of long pending disputes of high value if that system is resorted. But assuming that the parties do not agree for the same same person who is acting as an arbitrator. According to me, the skill set for mediator is no different from the skill set for the arbitrator, except that there has to be a little bit of training as to how the process has to go, which is not a rocket science.
Right.
Any eminent person who is in a position to act as an arbitrator with a little bit of orientation can pick up the nuances of mediation very fast in no time. In fact, a day or 2 days workshop can do the wonders for the experienced people, particularly those who have been judges or who have been senior advocates for long time. So those senior persons can pick it up very fast. And those senior persons, because of their eminence, can also play a role in reducing this trust deficit. And the parties can have an increased trust level in their credibility, in their ingenuity to find a solution, and also other aspects which are there in the decision making process to agree on a person to act as a mediator. Once you have that trust in that person, then irrespective of the technicalities of that particular dispute, when you are looking for a mediation, you are basically looking for a solution. For a solution in terms of what? In terms of money, in terms of economics. So therefore, there it is the economics which takes precedence if it is a money matter, or if it is other matters, for instance, pertaining to say a patent or publication industry dispute or technology dispute, then just a little bit of understanding, which any person at that level is in a position to do. You don't really have to be an engineer to understand that, or a scientist to understand that, because you are not going into the merits of the disputes in that detail, because you are mediating. You are trying to find a common ground. So at a common ground, if the parties can meet and there is a bit of give and take, and the mediator is able to make them realize that your continuous or your continuing with this dispute is not yielding any benefit to both of you, and you are only losing in terms of time or in terms of interest or in terms of cost, then maybe that light of wisdom dawns upon them and they are able to resolve their dispute, because ultimately it is the mediator only who can tell them that, look, all the disputes in this world are between right and right. Because you think that you are right, I think that I am right. So therefore, we have to find a midway. So we are not saying that you are wrong or this person is wrong. So first of all, that approach creeps in immediately when you go for a mediation. That we are not looking to find faults. We are not trying to condemn any of the party for any of the breaches which are alleged against each other. We are trying to find a midway. So that being the objective, that changes the course of discussion. And then both the parties, that they weigh their options, they weigh their pros and cons. And then there is a greater possibility that a high value dispute is resolved in a much faster time than in any other proceedings. And assuming due to unfortunately for any reason it fails, then you can always go back to the arbitration or the other adjudication mechanism in which you were engaged earlier. So ordinarily these mediations are not timeless, in the sense that they all are time bound. And the parties, because there's another problem in this country why the mediation doesn't succeed, is this, that just like the lawyers are busy, so they take they see their calendar, the arbitrators see their calendars, and then ultimately the next date or the time between the two dates when they are sitting is quite long. So in mediation, it can succeed in India only if there are dedicated resources. I mean, there are people who are dedicated mediators. There are the parties should pick up their legal team who are able to give time and assist the mediator in
You mean
arriving.
the gains will be lost if too much
Yes,
time
too
lapses
much time.
between two hearings.
Yes.
That is what you're saying.
Yes, because today arbitration system is being accused of not yielding the desirable result. But then see, who is responsible? The stakeholders are responsible.
Yes.
If the parties themselves, they want, no, that this date is not suiting me, that
Yes.
date is not suiting me. So ultimately, if you want a system to work, you have to invest in the system.
Yes.
And when you invest in the system, means that you have to invest in the system not in terms of money, in terms of your commitment and dedication.
Point 20.
So the same commitment and dedication, if it is invested in mediation,
Yes.
then I have no doubt that mediation will yield enormous result, because ultimately what we are waiting for, we are waiting to have a result, somebody announcing that yes, this system is efficacious,
Yes.
this system has efficiency,
Yes.
and it is a viable system.
Viable system.
So, and why we have not reached there? Because of the trust deficit.
Trust deficit is an important point you raised. Now I'm going to go to the very root of the problem. You, Dr. Gemawat, represent the GCI. All GCs are not willing to concede anything when in the adversarial system. That all I want, I'll get from the court. So both want everything. But in mediation, as Justice Sikri in the earlier shows have also said that you have to concede something in mediation. Do you think this approach also causes a problem, that there is a pressure from the shareholders on the legal heads of the companies that you will not concede anything? It's not that the shareholders tell you every day, but it is an unsaid pressure that you have to deliver for the company, so you will not concede anything. But mediation requires for you to concede something. Is that a problem?
Well, Tarun, answer is yes and no both. Let's go to the root of the issue.
Yes.
Why these disputes arise, and particularly if I limit my discussion on the PPP project, because we are right now talking about infrastructure projects. The whole foundation of PPP projects, once they enter into a relationship, it's not a partnership. It's an adversarial system in the implementation of the project.
Oh.
Because there's one government and the private party. Government, once the project gets executed, the contract gets executed, then government takes a back seat.
Oh.
And they would create all those issues whereby even if they can support, there is no support coming. So adversarial system is there in the implementation of the project.
Oh.
Now you look at the issues, how the dispute arise. Disputes are largely, if I want to categorize this, it's in three kinds of classes. One is a contracts related issues, which is basically contract interpretation.
Okay.
It's lack of understanding about the contract, what we have written, what we have understood, and something like that. That is one kind of dispute. Second kind of dispute is commercial in nature.
Commercial.
Conditions have changed. You have, because of your financial decision making or technical issues and otherwise, there are certain changes in the commercial part of it. And the third, and largely, the third category is very important. These are behavioral issues. We will teach you a lesson.
Okay.
Now, when you have the disputes arising out of these three categories, and at that point of time, you come out with, and just think about it, adversarial system in the implementation of the project, then these three categories of issues which are arising out of this, and then you offer something on the mediation on the table. Now, mediation essentially means what? Just you rightly pointed out the trust deficit part and all that. But then important thing is there any willingness of the parties to settle through mediation?
Yes.
When this willingness would come? Willingness, perhaps one area which attracts me is that when there is a continuing relationship, even otherwise, there are smaller issues which can be addressed through that kind of negotiation,
Agreed.
through a mediation process.
Agreed.
But where the contract is getting terminated, or where the consequences is a huge outflow of money by either party.
Okay.
By either party, whether from a government or from a private party, or even otherwise between two private parties. The moment there is an outflow of funds, because all consequences of all the issues, whether commercial disputes or this contractual disputes or behavioral issues, there would be somewhere the consequence is outflow of money from one party to the another.
Yes.
The moment that comes, the parties would take a position that would I be better off in terms of litigating on this issue for a number of years, or would I be better off in terms of settling it through mediation?
Okay.
And settling it in mediation essentially means what? You need to come out somewhere with your facts and figures,
Yes.
with your data,
Yes.
particularly in a complex issues, whereby the mediator would convince you how the mediator works. Mediator would be giving a fear between both the parties that if you try to go through a litigation route, it will not serve your problem. You will end up suffering because of this litigation. So that is the fear, or whatever approach he follows in terms of creating that consensus, in terms of bringing them to the table. But difficulty here is that whether in complex issues parties would be upfront in terms of opening their cards.
Okay.
In terms of legal issues as well as factual issues.
Yes.
Because the moment you do that, and if suppose mediation doesn't settle, it doesn't get settled, then essentially it means either you are going in the arbitration route or the litigation route. Even if theoretically it is fine, it says that no mediation we will not be producing before the arbitration, or whatever, it's a confidential in nature, etc. But the fact remains that somewhere parties are exposing themselves.
Yes.
And that is the reason why it is not working. And perhaps it would not work also, in my view, large complex transactions where termination has already happened. It's
You
leading
mean
to
when the
termination.
relationship has bond beyond the point of no return? Only in those cases.
Exactly. But then where the relationship is continuing, for example, in a contractual dispute, a contract of say liquidated damages because of you have delayed it for a certain period, etc., and you are getting into a dispute of that nature, or there is a dispute in terms of your key performance indicators in a contract was this, you have not performed this, and because of this there is a penalty, etc. Those kind of smaller issues can get addressed through mediation process, perhaps.
One small example,
Yeah.
usually land acquisition is the biggest problem in this country, which
Yes.
leads to most arbitrations.
Yes.
Because they ask for more in terms of payments from the government if the government is the party.
Yes.
In these kind of cases, what is the solution?
Well,
is mediation the solution here?
In these kind of course, you rightly pointed out, these can be perhaps, of course, depending upon the nature of dispute. But then these are the opportunities whereby no party is suffering, because if you are settling the issues through a mediation process, perhaps there is a win-win situation, and that win-win situation might work. But in a situation where there is no win-win kind of situation, mediation leading to ultimately a situation of outflow of funds from one party to another, perhaps parties would be apprehensive in terms of getting into that.
Thank you. Thank you for sharing all these aspects. We'll go to Justice Sikri for his, in a sense, sort of opinion on what both have spoken, Senior Advocate Sanjay Jain and Dr. Gemawat.
You see, I think Mr. Sanjay Jain emphasized again and again, to which Dr. Gemawat also supported that trust deficit. And then he mentioned the types of cases where it would still not be possible.
Yes.
Let me here give my 2 or 3 comments. Yes, trust deficit, because many do not know the miracles of mediation today and what it can achieve. As rightly pointed out by Mr. Jain about the process, etc., which can generate that kind. So if the advocates or other stakeholders come to know that no, it can bring us some kind of solutions which are keeping in view our interest and not our position, they are ready to forsake their positions, and they are ready to come to that interest, and that as it's not, as we say, from vivad to samvad,
Right.
from debate to dialogue.
Right.
So it's not that from argument to dialogue. So when the two persons are arguing, you are right, I am right, but where both of us are right, where it's the common ground, which was mentioned. So that is very important, and in order to create that trust, parties should understand this. But I may add here, I am happy that is in spite of the pessimistic picture to some extent given by Dr. Gemawat, over a period of time, because I have seen mediation in this country right from very beginning, inception in 2005. I was associated with in the High Court when it started our 2005 or 6 from very beginning, and I have seen how it has grown. Initially, as Mr. Jain knows, when this pilot project started in Tees Hazari by the Supreme Court of India, it was boycotted by lawyers.
Okay.
Lawyers thought that it is going to take away their profession.
Right.
As I always say, ADR, they thought it's not alternate dispute resolution, it is alarming drop in revenue for the lawyers. So that was, but today that thinking has totally changed in 17, 18 years. Most of the lawyers feel that no, mediation is good, and they are able to tell their parties also. Likewise, business world is also realizing no, it is good, but because it is Dr. Gamawat and other of these general counsel who are there and heading such big enterprises, they also know what is happening in the world around,
yes,
and in the mediation world.
Yes.
So they know the benefits of mediation, and therefore, because I had some of the stories, if I tell you, which will prove that mediation under certain circumstances is the best this thing, and where he gave the example of this PPP, and where the termination also takes place, etc. Now, say for an example, NHAI highway project, which somebody has constructed that and accepting that toll, etc. For 25 years, 30 years, the contract was there. He has invested 1,000 crores, maybe 20-30% is equity, other loan, debt, etc., which is taken, and all that is all in the captured, and bank account is opened. How when the money comes, waterfall mechanism is there. How much it would be, the loan has to be serviced first, and it's a tripartite agreement with the bank also on all that. But what happens, Dr. Gamawat said that, look, if it is going on, mediation can take place, but if it is terminated, even on termination, these contracts provide termination payment.
Okay.
So because then the project where the contractor had invested 800 to 1,000 crores is taken over by the government.
Yes.
But that doesn't mean I had invested, my investment should go totally. So therefore, all this contract provides, if the termination is wrong by the government, them and entitled to one kind of payment, which is quite high, which is total debt due plus maybe 20% or 30% more, sometimes that, so that I get back my money. Termination is and that is provided in the contract itself. Formula is provided. Even if the termination is right, still I am entitled to at least particularly debt due, etc., so that I am able to service the debt, because not that the government takes over my project where I had invested 100, 800 crores, 1,000 crores, and today I am left high and dry. But therefore, in those cases also, there would always be an interest, even if it is terminated, that I get my money as soon as possible, whichever way.
Right.
And I'll be able to sacrifice, because I tell you another thing. Now with insolvency regime coming, IBC is there, that normally special purpose vehicles are created, a special company is created by consortium or one for that particular project. It's always there. But then if after it is terminated and that company doesn't have any other business.
Yes.
So therefore what happens, and debts are there.
Yes.
If I don't get my money immediately, bank would go against, and these types of cases are coming up.
Okay.
And they would go to the court, and they before, suppose, and I have seen where the arbitrations are raised, before the arbitration could be decided, the company has gone into liquidation because it could not do so. So in such a situation, where mediation is the best choice.
Yes, true.
Because they will get the money and the company will be saved.
Yes.
So therefore, whichever way, even the employer knows, I have to either pay, even if termination is correct, I have still to pay. So why not on that? Even these cases, under certain circumstances, can be the best option.
True.
Here, that is why I said that to some extent, I differ with Dr. Gamawat on this. And let me give you another example, because I had many examples of success stories of mediation, but time may not permit, so I may give one example. To tell you, there was one, it was one company, of course, where the promoters were there. One of them went out of that, from that company, and the shareholders agreement was entered into, where they said that, others said that, okay, we'll buy your shares. You want to go out, and it was peacefully done, and we'll buy within 2 years, and this would be the value of shares, etc. They did not. It was a construction company, and 5-6 years ago, you know that construction industry was not doing well, so they didn't have liquidity. That this person now goes to and raises the arbitration. He succeeds in arbitration. award is passed, because the agreement was there. Under the agreement, he could get that award, and the at the rate at which the shares were to be, and this was all stated there, and plus IRR, etc., and all that, and it was, I think, 200 crores award which he got, 200 plus. Section 34 petition was filed challenging that award. Section 34 dismissed. So that was also in his favor. They filed appeal.
Yes.
At appeal, the matter was sent to me for mediation. Now, very interesting thing happens there. And that's what we say, that from position to interest. Now, what was the position? And during now mediation, he comes down to almost, if he had to get 200 plus crores, 100 something.
Is it so much?
Yeah, because now I'm here answering another question also. Sometimes he says that it fails because the parties do not want to disclose their cards, because if it doesn't succeed, then it has to go back to the, yes, he's right to some extent, but there's one caveat here also, that many times during mediation, if you know the mediation process, if I don't want to, one party doesn't want to tell something to other, there are what we call caucus session. In private, I can tell only the mediator, which is with the consent of the other side. And if I tell the mediator that this is my private thing and all that information, I'm revealing it to you, you don't have to disclose. But mediator gets, his hand gets strengthened, that he comes to know that what is his interest, and likewise he can have similar session with other. So mostly, many times, the information which they don't want the other side should know, if the mediation fails, they can tell the mediator in private, which is not shared commonly. So that process is also there. So coming back to that case, so therefore here in private sessions, he told me that, and he come down to, as I said, 100, 135. Why? Because he had to pay huge loans to he had taken from the bank, he had to pay that.
Oh, so he was desperate.
He was desperate. He said, if I don't pay, I will be declared insolvent, and my company, because the banks were threatening to go to the insolvency court and CLT against him. So he wanted to save that situation. In private session, when I talked to the other side, I said, look, you are getting such a lucrative offer, why don't you agree?
Yes.
They said that it's very good offer, but we don't have money.
Oh, so they didn't even have
how we pay. So that is the problem. At least now their interest was, okay, if it goes back to court, in private session I told them also that, look, your lawyer is there, what chance you have in a case where award is against you. Section 34 has also appealed. Most likely there are hardly any good grounds that you will succeed. Say, but we'll be able to buy time. No Indian system. We'll be able to buy times, and that's why we are not. Now, in a situation like this is what we call impasse or deadlock situation. Both sides want. They are ready to pay that 135 and all, because that was very lucrative offer, and if it goes back to court, then 200 plus further interest, it may have swollen to 300 crores.
Yes.
So for them it was good, but then they were helpless.
Yes.
For him, he wanted less because he wanted to pay to the bank.
Yes.
Now, we totally diverted the situation. That in what way? So when the other side, to that extent, he agreed that you can tell them that I have to pay to the other side, to the bank, and that is why when it was said, now here interest come, and from position to interest, and how the problem is solved. Say that you want X is the bank from there. The other side say, I know those bankers very well.
Right.
I'll get you time.
Yes.
Correct?
Yes.
To that, okay, so they will not file case against you. We will go there. I'll get you time. I'll stand, because this company, which was not in a position to pay at that time, otherwise they were very good. They had much assets, etc., many projects going on, but liquidity was not there at that time.
Yes.
So, but they had good credentials, good goodwill was there,
yes.
so that we can solve that. Second thing, because this other person who had gone out had started his own construction business, so his few projects were in jeopardy. He was not able to. So we will help you to develop those projects.
Yes.
Now because of this and seeing the interest of both the parties, what kind of solution? That was deferred, the payment, etc. and again sort of quasi partnership entered
Developed.
into. His projects were, he helped, so that other side who has to pay money helps this side in settling the matter with the bank, in deferring, and ultimately I told that the matter stood settled. Therefore it went on well, and those projects which were half baked and he was not able to, so they gave their technical support, other support, and they saw that those projects are completed.
Okay.
So it was a win-win situation. After 1 or 2 years, both were happy, and they could buy those shares also from him and pay him his amount.
So
So
basically-
these are some of the things which can't happen in adjudication. What would have happened? Both the companies would have gone into liquidation, I am telling you.
Yes.
Had this continued.
Yes.
Because they would have suffered the award of 200, 300 crores, not in a position to pay, go to liquidation.
Yes.
This man is not getting money in time. Banks go to IBC,
He goes to liquidation.
So both would have finished, and he had both survived.
This is very
This is
interesting.
and I have so many examples like this. But this is the beauty of mediation.
This is very interesting. What you shared was actually revealing to all of us in a sense, and a lot of viewers also will take inputs
On
from
mediation, arbitration, if you have time, if I tell you in 2 minutes only.
Yeah.
Again, it was a case where this ICC arbitration,
Yes.
and it started 15, 16 years ago,
Yes.
one matter. So their dispute arose between the parties. It was that again shareholders agreement in the beginning, telecom company.
Yes.
And some foreign investors had come at that time. So it was, and that there were two Indian, one promoter of that company, one other who was shareholder, but his shareholding was very less. But then this agreement was that if they go out and they buy, we will purchase. So here everything that promoter company, it buys, those 3 or 4 foreign investors, they go, dispute is not between them. Now he says that I had to have my share in this, I would have purchased those shares, how you could do so. So he raised ICC dispute. The other company goes to Delhi High Court, takes an anti-suit injunction. It's not an international arbitration. What disputes have remained between two of us has nothing to do with that. ICC clause doesn't apply. Injunction was given. So proceedings were stayed in ICC. This continued for 10 years or
10
maybe
years.
more. Ultimately, suit was decided, suit was dismissed. No, it's a subject matter which can go for arbitration. Appeal was filed. Now, in appeal, again, this was matter referred to me for mediation. Now, when we sat, I said that, look, now 15, 16 years have passed. At that time, you had gone. So, there are many issues which were there 15 years ago have become redundant. So, we could settle, I could discuss with the parties and narrow the disputes. Now, after narrowed down the disputes, then we started discussing about it. 80% I could resolve.
80%.
80% I could resolve. Now 20% there was no, the parties were not settling, and it was more legal rights under the agreement where they had their different interpretations, so they were not budging. And it was purely rested on that interpretation of that. He says, my certain more rights arise because of these clauses, the other side was disputing. And at that stage I could convince them, and both were persuaded. I said that, look, if this is you are not settling, don't treat it as total failure. All those areas where you have settled, let us enter into a settlement agreement, so that the court decides only 20%.
residue only.
And now appeal is pending. If in appeal court decides that there is no arbitration, then suit will have to be filed, you do that. Or it will go to arbitration also, then only that 20% parties agreed. But then once they were agreeing and we drew the agreement, both of them came out with this, that look, only 20% is settled. Even if I succeed, that party said, in the court now, ICC, what I have to do with ICC? With the 20% going to ICC international arbitration, we two, all the Indians are left. So let us now decide this 20%, and they requested me of their own, you become the arbitrator, and we are putting an arbitration clause superseding earlier arbitration. That's this, what remains, you decide.
Okay.
So settlement took place, partly mediated, 20% which were left, arbitration, and I gave the award within 1 month because it was only
So
a legal
arbitration,
issue.
mediation, both
Both were. So it's a unique combination where, so therefore you have to act depending upon what is the dispute, what are the interests of the parties, and where the parties are. and how the combination of arbitration and mediation can also be very successful.
Thank you, thank you. We're really indebted to you for sharing these two anecdotes. Will be useful to a lot of viewers and people in the industry. We are out of time on this show, but I would request the indulgence of all three of you if you could join us on the next show, which we do in a month's time, where we'll only discuss NHAI projects, because as we all know, lakhs of crores are going to build urban infrastructure. And of course, we do something on PPP later on, but I think road projects are something that needs a lot of attention in India, because even when roads are made, the quality sometimes is an issue, and that leads to a lot of disputes immediately after the roads are opened. In the recent times, we have seen some very marquee.
Sometimes even when roads are there, this is, as he said very correctly, sometimes dispute is that now the concessionaire is not maintaining the road. O&M disputes arise.
While he continues to...
Yes, continues to collect the money.
Sometimes that is the dispute. Sometimes the difficulty is this, that the local population says that you remove the toll from this place, so it has to be relocated.
One thing that I would seek your indulgence in the next show is that when contracts are entered into with private parties for 30 years, should there be a certain certainty for the private party that governments may change, bureaucrats may change, but they shouldn't be cold-shouldered after 10, 12 years. Because in the end, the promoter is a trustee of the shareholders, which can be lakhs in number. And they get shaken when, because the government is all powerful. Governments like India are the most powerful. They can do anything. But when they do anything, it shakes the investors' confidence who's sitting abroad. And that is something that I would like to seek your indulgence on in the next show. So NHAI contracts, PPP is what we discussed, but each of you, your contribution to the show was invaluable, and I appreciate that all three of you could make time and come together for this one on a Sunday. Thank you so very much. Thank you, viewers. This is one of the most interesting shows that we did in the recent times. Lots of anecdotes, lots of examples, some plain speaking by Dr. Gemawat on expectations from the industry side, and some solutions that Justice Sikri presented. I hope you also enjoyed this, and we come back next month taking this agenda forward. But that's it for now. Thank you so very much for joining in. Thank you.